call the meeting of the Board of Ethics to order. It is 5:33, and we will do our pledge to allegiance to the flag that is over in that corner.
An imaginary flag.
10 minutes
Small.
there.
Okay.
Your vision.
You just want to see if we're going to do whatever you say.
No, not that bad.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. That's the first.
Yeah. Meeting
The
statement.
chairman would like to announce and have placed in the minutes that the Open Public Meetings Act requirements of law have been satisfied by publication in the two newspapers, which are, do I know?
News Tribune and Newark Star Ledger.
Thank you. And by posting a copy on the public bulletin board and on file in the office of the city clerk. Thank you.
And we'll do a roll call.
Who's going to, you want me to call the roll?
Yeah, you can do it.
Okay. Don Pincavage,
Here.
Anthony Jones,
Here.
Claire Barber,
Here.
Reverend Lauren Carrington,
Here.
Brother Jude Lasota.
Here.
And unfortunately, Reverend Francis Rilla not able to be here. He sent me an email saying that the water tank at his residence apparently burst, and his basement was full of water at the rectory, and he's had to move down to McGuire Air Force Base. I'm not sure what the connection is there, but there's mold all over the basement, and he doesn't know exactly when he's going to get back. He said he would be available by conference call, but I'm not sure that would be a good practice in this type of proceeding. So I think we're just...
He's here. Yeah.
Oh, you made it?
Yeah, I did.
You just made a liar out of me.
Thank you. I'm not supposed to be able to make it, but
Yeah.
it's an important vote, so.
All right.
Thank you.
Going back to the Air Force Base?
I am tonight, yes, after I do, I'm kind of celebrating the Mass over at St. Charbel's Parish.
All right, so the record, the minutes will reflect that Reverend Francis did arrive, and we do now have a full complement of members, which is good, because as I explained to you previously, the rules of procedure require a 2/3 majority in order to make a finding. So that makes it very difficult if you only have 4 people. You gotta have all 4 agree, and that doesn't always happen. All right, Chairwoman, Chairperson, if you wish to proceed.
Yeah, let's proceed with our agenda. We would have our old business is, first we will hear the complaint by Charles Cradaville against Andrea Eato-White.
Yes, is Miss Eato-White is here.
Okay.
Would you like to come forward, and maybe we could get a seat for Ms. Eato-White, so that she could...
Would you like me to sit at the table?
wherever she's comfortable, if that's... why don't you put her right there?
Right there, so
That's
that you
fine.
can see everybody in the room.
Yes.
Okay. You want to use the table?
Before Ms. Eato-White testifies, maybe I could just go over the substance of the complaint filed by Mr. Cradaville. And there's actually a complaint and an amended complaint. The original complaint, signed and sworn and subscribed by Mr. Cradaville, is dated February the 1st, 2017. And in that document, he says that Ms. Eato-White has been an employee of the New Brunswick Housing Authority continuously since January 18th, 1995. She was subsequently appointed to the position of a member of the New Brunswick Parking Authority. I get a little confused sometimes with the letters. There's the NBPA, which is the Housing Authority, and the NBPA, which is the Parking Authority. So you have to keep those separate in your mind. She was appointed to the Board of Commissioners of the NJPA on June the 3rd, 2015, and has served continuously since that time. As such, being on the Board of Commissioners made Ms. Eato-White a LGO, a local government officer, who was required to file a financial disclosure statement. And it recites that when she was appointed in 2015, she did not file a statement. She was appointed in the middle of the year, to not file a statement for 2015, and that she filed an inaccurate and deficient statement on April 29th of 2016. The substance of it is that she made some mistakes on the form. She did not put the sources of her earned and unearned income. She put earned income and unearned income for certain items. So that's alleged to be deficient, and allegedly misidentified her own property on the form. And I think that's the relevant portions of the complaint. And then subsequently on March the 8th, why don't we have this marked for the record?
A1 mark.
C1 or C1. And then subsequently, thank you, on March the 19th, 2017, Mr. Gardville filed an amended complaint with this board. And the complaint contains the original allegations of the first complaint, and then adds additional information regarding an alleged reimbursement or prepaid expenses which were received by Ms. Eato-White in connection with travel to Huntsville, Alabama, and her lodging at that location, and that she allegedly did not disclose that information on her FDS, and that would be another violation of the financial disclosure requirements of the local ethics law. It's kind of interesting. The form doesn't require you to tell how much, it just requires you to tell the source of the reimbursement or prepaid expense that you received. In this case, it was, I believe, allegedly from the New Brunswick Housing Authority. So this is the amended complaint. Why don't we have that marked as part of the record as C2. All right, now, I guess this would be an appropriate time to hear from Ms. Eato-White. Now, Ms. Eato-White, you're here you're apparently not represented by counsel, is that correct?
Correct.
And you understand you have the right to have an attorney if you so choose?
Yes.
Okay. Maybe I could, and the board could ask you some questions to try to elicit the information that we need to make a decision in this matter. Do you want to start out by making a statement, or?
I would like to.
Okay, that's fine.
First of all, good afternoon. At the time, I got sworn in 2015 and signed the paperwork and was awarded my title as being the Commissioner of the Parking Authority. That's all was done at that time in 2015. I replaced somebody else that was initially on the board. So after making the error, my first time submitting a 2016 FDS, I wasn't even aware that an FDS was, the financial disclosure statement was required. So in 2015, I never got a financial statement. At the time when we were in a Parking Authority Board meeting, and Charlie brought up about my error in 2016. It was my first time submitting a 2016, and I did make the error, and I did correct it. But when I went to the second page, I clicked down the wrong borough. Once that was brought back up, I went in and amended that to correct it to read New Brunswick rather than Middlesex. Going back to the reason why a 2015 was not submitted, I wasn't aware of it until then. I called the state, worked with the state. They told me what to do, how to log on, because my paperwork clearly states that this is my first time log on. Okay, I went in 2017, to try to correct what needed to be done. They told me to drop down the window of the year, click on 2015, and you should receive a blank form in order to submit your 2015 federal disclosure statement. It didn't work. I called back. They stayed on the phone with me. They said, wait a minute, go back out, pull up the roster. I have it on my screen. Repeat your name to me again. I did so. My name is not listed on the roster for the city. And once again, not being aware of that, that's a requirement until it was brought up in the meeting that I didn't disclose the 2015 statement. After talking with the state, I then went down and I went to the city clerk's office to explain to them that the state clearly told me, you're not on the roster for 2015. Your name should have been submitted. It was not submitted, and I have a copy of the roster that was submitted. They submitted their roster in April. I took office, I believe it was in May, after they submitted it. They didn't do an amendment, which I'm saying amendment because that's what I would do, amend it to add me on to it. Then I would be able to report the necessary information for 2015.
Okay.
So that's why there's no 2015, and the state said, you're not on the roster. You don't have a log on. Your log on began in 2016. When I submitted my 2016, once again, I made an error. I corrected the error. I made two errors, two different times. The initial, when I first did it, I did it as unearned income for my spouse because it was Social Security and pension. So that was my mind thing that he's not physically working, it was just me. So mine said earned, his said unearned. And that was a mistake from me, first time doing it by myself. So now I know that it's considered earned income, and you'll see that my 2017 is done properly. And unfortunately, it was unknown to me for 2015, otherwise it would have been a successful submittal because that would have been my first time.
Okay. Maybe just to clarify that, my secretary was kind enough to download copies of what you uploaded to the website. Maybe we could put these in the record. First is your original FDS financial disclosure statement for 2016. Could we mark that, please? Maybe C3. Sure. I guess this was your first try, and you listed the block and lot of your real estate as block 555, lot 014, which is that the correct?
That is correct.
Correct reference, but you put Middlesex Borough instead of, and Middlesex County instead of City of New Brunswick.
Yeah.
Also on the section Roman numeral 2, under Part A, where it said name of each source of income, instead of giving the name of the source, you put earned income, unearned income, unearned income. So that was the... also, you did not put anything for any reimbursements or prepaid expenses. Then you submitted an amended FDS, and that was, the original was submitted on April the 29th, 2016, I believe, yes. Then you submitted on January the 20th, 2017, and this one we marked this C4. An amended return, amended statement. And that one you made some corrections, sorry. You made some corrections on it. You put the correct names of the sources of your earned and unearned income. You still had Middlesex Borough, and you didn't have anything about the prepaid expenses, but you did correct something. Then you again attempted to amend on March the 8th, 2017. Why don't we mark that one too? That'll be C5. And you corrected the city of your residence to New Brunswick, although you did not put the address of the actual address of the property. I think that was the correction you made for that attempt. That was on March the 8th of 17, and then the last iteration was dated May the 3rd, 2017. Can we mark that one for ID too, please? That would be C6. And I think the change you made on that was you included the address of your residence. So that was the only thing that isn't there that possibly should be is the question of reimbursements or prepaid expenses for 2016, which would have been something you received in 2015. That's,
Yeah,
so
I didn't know that because I went on the year, which was 2016.
yeah. Well, we'll get to that in a minute. And then I just wanted to note you did file a proper financial disclosure statement apparently in 2017, dated April the 27th, 2017. And you have all the information that you had in the previous year, plus under section Roman numeral 2C, it says state the name and address of each source of gifts, reimbursements, or prepaid expenses having an aggregate value exceeding $400 from any single source, and you have the New Brunswick Housing Authority as a source. So maybe we'll just mark that for the record. 7. So, I guess, do you mind if I ask?
No, go ahead.
Yeah, sorry. The complaint, or I guess the amended complaint indicates that you received some money for a trip, in connection with a trip to Huntsville, Alabama. There is a copy of a check request form that was approved by the executive director of the Housing Authority in the amount of $600, and then there was a receipt or confirmation of housing charge of $745.02. Was that, these were monies that were paid on your behalf in connection with a trip to Huntsville, Alabama, is that correct?
Right, for training,
Or training?
yes.
And this was approved by your supervisor,
The executive director.
executive director?
Yes,
So, and this would have been in the summer of 2015,
yes, it was August of 2015.
okay? So, you did, in essence, receive that prepaid expense, okay?
Yes.
All right.
Excuse me, can I just have a
Sure.
question? Just maybe cut through this a little bit. Did you ever document that expense anyplace?
No, because I didn't really know until, you know, it was 2015, so my 2016, I just look at the current year for 2016 and for 2017, how there's no expense for 2016, but for 2017, there is.
Yes, ma'am. So it wasn't documented?
It wasn't documented, it would have been if I got a 2015 FDS.
Yeah.
So, and what I did hear was that you attempted to do 2015, but because
Yes,
you were
with the
not
state.
listed as an employee,
Right.
that you couldn't add it, you could not complete it, because
Yes,
you weren't on the list,
yes,
on the city's list of employees.
yes.
And it's a little confusing. Obviously, I believe when you file for 2016, you are filing for what you received in 2015. So that's, you may not have been aware of that.
No, I wasn't, sir.
And you're indicating that you were not aware of that. So that's probably the source of some of the confusion.
Yeah.
Sir, at this point, can an amendment be done? Is that possible?
I could amend the 2016,
Oh,
I was
yeah,
trying to
she's-
submit a 2015 because that's what it was stated that I didn't file, 2015, but I have no problem. I have my certifications because that's what I went to Huntsville, Alabama for, to get certified in another capacity of a job, an additional job and the duties that I'm performing. So I have no problem with going in. That would be great. This way they can see that it is documented and willingly documenting, and now knowingly I can do it in 2016, even though, you know, it wasn't put on there. I could just go in and amend the 2016 and include,
Okay.
since it's supposed to be for 2015. So
yeah,
everything's
yeah,
for the
that's-
prior year. Now I have clarification on that also.
Yeah, it's confusing, admittedly.
But I know now,
Um,
and I'm glad.
So you are willing to go and do another amendment to your
Yeah.
2016 FDS? All right.
Is there someplace that she could go, actually go to and make sure that goes through so it doesn't kind of pile on now? Is there, can you go down to a particular office and do it, or must it be done at a computer from a remote site? Because I know in the military, when we're having problems with paperwork, like if I'm having problems with finance, I'll go to finance and I'll have a computer there. We'll have a customer service person make sure that I fill out those papers correctly. Is there some customer service or help desk that you can
I could, actually, I could use my personal computer, but I can call the state, and they're very nice, the gentleman and the young lady, and they will stay on the phone with me to make sure that it's done right.
Okay. It doesn't sound like there's too much of a factual issue here from what Ms. Eato-White has said and the testimony that she's given. Essentially, what was in the complaint is basically correct. It's just that you have an explanation for these events, basically that you didn't understand the requirements and that it was very confusing and you had problems getting that information on paper or in the computer. Does the board have any other questions that they wish to ask?
I just have a question. You said that 2015 you're not on a roster.
Yes.
That's why you couldn't do it. Even if Ms. Eato-White goes back and tries to amend 2015 and she's still not on a roster, she's not going to be able to amend it. So she would have to be amended
Well,
to the roster.
I don't know if there's an interconnection there. I don't know whether she'll still be able to do it even if she's not on a roster. The problem is that the local ethics law was amended back in 2008, I believe, and that said that if you're a newly appointed local government officer shall file a financial disclosure statement within 30 days of taking office. So even if it's after the normal deadline, which is, end of April, May 1st, maybe, even if you're appointed after May 1st, and she was, you're still supposed to go in and file one for that year as a newly appointed or elected local government officer. So she obviously was not aware of that requirement. Her testimony is that nobody made her aware of it, and that she furthermore wasn't on the roster. Which doesn't surprise me because the roster was made up long before that, based upon the information that was available at that time. So presumably someone should have made you aware of the requirement, and perhaps it got lost in the shuffle. Are there any other questions that the board wants to ask Ms. Eato-White? Under the board's procedures, there's kind of under the standard operating procedures, it says, neither the ordinance nor the Administrative Procedures Act provides for private prosecution or participation by third parties in this legislatively created function. However, in order to further a full and fair inquiry, the board shall solicit written questions from members of the public and, subject to their propriety, relevance, and admissibility, pose such questions to a witness prior to his or her dismissal as a witness. Determination by the chair whether to permit such questions shall be final. So it would, apparently according to the standard procedures of the board, you could ask the public if someone wants to submit a written question, and then you as chairperson could decide whether that is relevant or appropriate to be asked. So is there anybody in the audience that wishes to submit a written question to the board to be asked of the witness?
Yes, please.
Surprised. All right.
Does it have to be written?
Yes.
Yes, that's
Give me a
what
moment, then. I have three.
Does anybody else have any questions?
Continue to this.
pertaining to this particular matter. Thank you.
Welcome.
Short questions.
So does the chair need to look at that before this
Oh,
question is
yes,
asked?
definitely. I'm just going to look at it with you.
Oh.
Let's see. You know, I'm thinking maybe it might be appropriate to, at this point, the rules require you, prior to rendering a decision, to go into executive session to discuss it. Maybe this might be a good time to go into executive session. We can discuss these questions and whether you feel they're relevant. We can also discuss the resolution of the case, if you feel that's appropriate. And then come out and make a determination on both things at the same time.
Regarding this matter.
Regarding this
Just this
matter.
matter.
Yeah.
Are we supposed to see this, or is just the?
Well, we can, when we go into executive, we can, because I'm sure the chairperson might want your input.
So we are going to go into an executive session, so we stay here and they leave.
Probably the easiest thing is for us to stay here and the people to please leave. Can we have a vote to go into executive session to consider the matter and whether to ask the additional questions?
Okay.
Make a motion to go to
Second?
All in favor? Any opposed?
Can we have the video camera and everything taken out while we're in executive?
Well, in executive, yes, the camera would have to be removed.
Adjourn.
Yeah. The board has considered, do you want to talk on the matter of the three questions first?
Mr. Cradaville has submitted 3 questions that he wishes to be answered. I will read them and out loud so everyone's aware of what the questions were and let you know what our decision is regarding the questions. Okay? Why didn't you provide receipts to the New Brunswick Housing Authority to show how the $600 was spent? Question number 2, what was the specific certification you received as a result of your trip to Alabama? Question number 3 is, were there any travel prepaid expenses paid for you during 2016? The board believes that these questions are not relevant to the ethics board, so we're not going to ask that you answer those
To
questions.
this particular proceeding?
This particular proceeding, that we're not going to ask that you answer these questions. Okay?
All right, that disposes of that. I'm going to kind of wing it and try to read a resolution into the record for the board. And if you have any issues when I read, just jump up and let me know. This is Board of Ethics, City of New Brunswick, in the matter of Andrea Eato-White. Be it resolved that the Board of Ethics makes the following findings and conclusions in this matter. A complaint was filed with the Board of Ethics by Charles Cradaville of New Brunswick on February the 1st, 2017, alleging that Andrea Eato-White, an employee of the New Brunswick Housing Authority and who was appointed to the Board of Commissioners of the New Brunswick Parking Authority on June the 3rd, 2015, failed to file the required 2015 financial disclosure statement, FDS, and filed an inaccurate and deficient FDS on April the 29th, 2016. The complaint further alleges that on January the 20th, 2017, Ms. Eato-White filed an amended 2016 FDS that continued to include false information about her real estate holdings. On March the 19th, 2017, Charles Cradville filed an amended complaint with this board regarding Ms. Eato-White, which in addition to the allegations contained in the previous complaint, alleges that on March the 8th, 2017, Ms. Eato-White filed a second amended FDS that corrected the municipality where her home is located. However, the complaint alleges that Ms. Eato-White failed to disclose in her FDS that she received a $600 check from the NBPA to cover per diem expenses related to a trip authorized and funded by her employer, the NBPA, to Huntsville, Alabama. Also, as part of that trip, the NBPA allegedly paid $745.02 for Ms. Eato-White's accommodations at the Hilton Hotel in connection with said trip. The board adopted a resolution on April 24, 2017, stating that the board had reviewed the complaint and amended complaint and made a preliminary investigation in consideration of the matter, and that the board had determined that a reasonable doubt existed as to whether the above individual is in conflict with the city's code of ethics or any financial disclosure requirements. The board heard the sworn testimony of the respondent, Andrea Eato-White. Was she sworn?
No.
Ms. Eato-White, would you raise your hand? Do you swear that the testimony you gave in this matter is the truth, so help you God?
Yes.
Thank you. Heard the sworn testimony of the respondent, Andrea Eato-White. Ms. Eato-White testified that she was appointed to the NBPA Board of Commissioners on, that should be NBPA, right? Sorry. On June 3rd, 2015, she stated that she was not told that she was required to file a financial disclosure statement within 30 days of her appointment, as required by NJSA 48:9-22.6b, as amended, because she was not listed, and because she was not listed on the city clerk's list of persons required to file for the year 2015, and was not advised by anyone of her obligation to do so. She stated that her failure to file for 2015 was inadvertent, and that had she been advised of this obligation, she would have complied. With respect to the 2016 allegations, Ms. Eato-White stated that she attempted to fill out the 2016 FDS form, but was confused by the form and inadvertently listed information incorrectly. She listed the correct lot and block as to her residence, but omitted the address and incorrectly stated the property was located in Middlesex Borough, Middlesex County, rather than the city of New Brunswick, Middlesex County. With regard to Section 2A, sources of income, she stated that she inadvertently entered earned income and unearned income under name instead of the correct name of the sources of those earned and unearned incomes. It is noted that she did list the address of each source of income in each of her attempts to fill out the form. With regard to the allegations in the amended complaint, Ms. Eato-White acknowledged that she did receive a $600 check from the New Brunswick Housing Authority to cover her per diem expenses with regard to an approved trip to Huntsville, Alabama in 2015 for the purpose of obtaining your certification
My certification as a Section 8 housing manager.
as a Section 8 housing manager. Ms. Eato-White also acknowledged that the NBPA paid $745.02 for her accommodations at a Hilton Hotel during said trip. NJSA 48:9-22.6A3 provides that a local government officer filing a financial disclosure statement shall disclose each source of gifts, reimbursements, or prepaid expenses having an aggregate value exceeding $400 from any single source, including relatives, received by the LGO or a member of his immediate family during the preceding calendar year. Section 2.32.080 of the New Brunswick Code of Ethics specifies the same requirement. Accordingly, Ms. Eato-White should have listed the New Brunswick Housing Authority as a source of reimbursement or prepaid expenses having an aggregate value exceeding $400 in Section 2C of her 2016 financial disclosure statement. It appears that Ms. Eato-White has listed the New Brunswick Housing Authority as such a source on her 2017 FDS. The board is mindful that Ms. Eato-White may very well have been unaware of her obligation to file an FDS for the year 2015, since she was a new member of the NBPA Board of Commissioners and may not have been advised of her obligation to file. Similarly, the board finds it that Ms. Eato-White apparently attempted to file her 2015 financial disclosure statement at some point and had difficulty doing so because of the administrative and technological challenges involved with that. Is that correct? Or did
Because I wasn't on the roster, I was unable, so I'm going to...
And because she was not on the roster and was not able to. The board does find that Ms. Eato-White has not yet corrected her 2015 FDS to reflect the prepaid and prepaid reimbursements she received.
Excuse me, that
in
would be
2015.
2016.
Hmm?
That would be 2016.
She has to amend her 2016 to reflect the money she received in 2015
Correct.
for the trip. Okay. The board notes that Ms. Eato-White did file her 2017 FDS and does list the NBPA as a source of reimbursements or prepaid expenses having an aggregate value exceeding $400. In view of all the circumstances of this case, the board is constrained to find that Ms. Eato-White did fail to file a complete and accurate financial disclosure statement for 2016 and has not yet filed a FDS for the year 2015 in violation of the requirements of state and local law, period. However, in view of the circumstances in this particular case as explained by Ms. Eato-White and her attempts to comply with the statute, the board is going to allow Ms. Eato-White 30 days to complete the filing of the necessary information on her FDS for 2016 and to file the 2015 FDS. And requires Ms. Eato-White to report back to this board within 30 days as to whether she was successful in doing so, or if she was not successful, the reasons why, and that you have made good faith efforts, and if you're requesting more time, how much more time you need. So the board is essentially giving you a suspended sentence at this point.
Yes.
And the board feels that if Ms. Eato-White follows through with the remaining items, it is not necessary to levy a penalty against her in this matter. So that's the end of the resolution. Are there any comments or discussions by the board on the resolution?
Just in terms of accountability, that you, if for some reason you don't, if it's not for good cause, good reason, you will be fined. Okay, at the end of that 30-day period.
Correct. Yes, maybe I should add that to the resolution. If she fails to follow through, the board reserves the right to levy a fine or penalty in accordance with law. So, any other questions or comments on the resolution
To vote.
from the board?
You just have to vote.
Yeah, I know.
I'm sorry.
I'm just seeing if there was any other comments. Does somebody want to move the resolution?
I move that we move the resolution as stated by our attorney.
So the chair is going to leave the chair and make the motion,
Second.
and
Second
Tony
motion.
is seconding. Roll call vote, please. Oh, I guess I better do it. Don Kincavage,
Yes.
Anthony Jones,
Yes.
Clara Bell Barber,
Yes.
Reverend Lauren Carrington,
Yes.
Brother Jude Lasoto,
Yes.
and Reverend Francis Rella.
Yes.
So it's unanimous, and that concludes the matter of Eato-White.
Thank you.
Thank you for coming. You want to take a brief recess, or do you want to plow right ahead?
We can rest.
We will now hear the complaint filed by Charles Catterville against Leonard T. Bier.
Yeah, well, I'm going to take these items. This is the exhibits we have, C1 through 7. By the way, I've been advised by the powers that be to on transcript.
Okay.
Do you take these, or am I going to take these? Cost extra, put them in there? Yeah.
It's going to become, you know what
All right, Madam Chairperson, the next matter is Mr. Beal's case. And Counselor, would you like to enter your appearance?
Absolutely. James M. Burns, law firm Genova Burns, Newark, New Jersey, on behalf of Mr. Bier.
And the record will show that Mr. Bier is present.
Yes, sir.
All right. Why don't I just briefly review the complaint and amended complaint in this matter?
Why don't we just swear them in? Or do we have to?
Well, after we
Okay.
review the
That's fine.
complaint.
Just make sure.
Yeah. Yeah, we'll try not to forget this time.
You got a lot on your plate.
Yeah. The first complaint in this matter was filed on February the 1st, 2017 by Charles Catterville and against Leonard T. Bier. And the statement in the complaint is that continuously since at least 2008, Leonard T. Bier has served as general legal counsel to the New Jersey Parking Authority, NBPA, and as such is required to file a financial disclosure statement under the local government ethics law. And according to the local government ethics law, Mr. Bier must disclose all prior year's sources of income in excess of $2,000, including his pension income. It recites that Mr. Bier has collected a pension from the state of New Jersey since 2008, and that he allegedly failed to disclose his pension as a source of income on his financial disclosure statement. Again, bear in mind, he's not required to file the amount of it, only the source of the income. And this complaint was filed with regard to, I believe, his 2015 FDS. And then the complaint goes on to recite that Mr. Bier, in 2016, his 2016 financial disclosure statement filed on April 4th, 2016, includes the following items listed as sources of income that did not appear in his 2015 form. Office rental income, 144 Livingston Avenue, New Brunswick. Rental income condominium, 7501 East Treasures Drive, Unit 5P, North Bay Village, Florida. Interest income, Cheap Eats LLC, 1482 Main Street, Rahway, New Jersey. Interest income, Yellowbrook Properties LLC, 247 Bridge Avenue, Suite 5, Red Bank, New Jersey. So the inference is that if he had this income in 2016, he probably had it in 2015, and it should have been on his 2015 financial disclosure. Can we have that marked just for the record, C1? Subsequently, sorry, keep jumping the gun on you. Thank you. Subsequently, on March 19th, 2017, Mr. Credeville filed an amended complaint with this board, which contains the same allegations as the previous complaint and the following additional allegations, that Mr. Bier has been the owner of a company called Bier Associates and a building at 144 Livingston Avenue in New Brunswick, that an organization known as Timothy Haas, H-A-A-H-S, and Associates has also used that same address. And he recites that Mr. Bier was the chairman of the Parking Authority's annual reorganization meeting held on January the 28th, 2016. And in the course of acting as chairman, continued to run the entire meeting, and as such, he presided over all of the items in the agenda, which included the retaining of himself as the Parking Authority Council, and also the hiring of Bier Associates and Timothy Haas and Associates as parking consultants to be hired by the NBPA. And that this was, by doing this, Mr. Bier took official action to benefit himself in violation of the local government ethics law and the ethics of the city of New Brunswick. So I think that's the essence of the complaint. We have this second amended complaint dated March 19th. We have that marked for identification, please. C2. Thank you. And Now, I want to note for the record, of course, that Mr. Bier is represented by counsel, Mr. Burns, and Mr. Burns has submitted a written response to the charges, and I believe you all received copies of this response and have had an opportunity to review it. At this point, I guess it would be appropriate.
I was asking any of the pictures to swear.
Oh, well, we can swear you in now if you want. You want to raise your right hand and swear that the testimony you will give in this matter shall be the truth, so help you God.
Thank you.
Thank you. All right, and now, Mr. Burns, did you want to make an opening statement on behalf of your client at this point?
Sure,
or-
very briefly, and thank you, council and members of the commission. Did you mark our letter, the June 26th letter?
No, I will do that.
Yeah, just so that that's in the record. I
Yes.
want to draw the commission's attention to it, obviously.
Let me get the copy. I have a copy here that I especially copied, so I would have it marked, and of course I can't find it. Let's just take a second. Here it is. Okay. You want it marked any particular,
Your choice, council. Sure.
R1 maybe? Okay. Thank you. Sorry, Counselor.
Thank you very much. Members of the commission, I mentioned the letter because we really tried, and Mr. Bier was as forthcoming on the merits of this as you could possibly be. Went right to address all of the allegations. We put them in detail in the letter so that you have the opportunity to see that. There's no intent to evade or to dispute, with one exception, which I will get to, at least in terms of a mistake that was made, and it was quickly corrected. I want to draw the Commission's attention to the fact that this matter actually was initiated even by Mr. Bier in March of 2016, when he self-reported this to this Commission, and then undertook, and he had some issues, which Mr. Bier is here to explain, answer any questions about the difficulties with changing the form online. I know we heard some of that earlier this evening. Noting my technical skills, I hope I never have to file one of these because I'm sure I would be in the same boat. And so, you know, it's a matter where there's complete candor on the part of the professional. I'll point out also that Mr. Bier is neither an employee of the Parking Authority, nor is he an elected official or a voting commissioner. We're not challenging his status as a local government officer, but I am saying it's the thinnest connection, and his compensation is through a publicly bid contract, which any law firm or anyone could bid on. This so happens that Mr. Bier is one of the most esteemed authorities on this area of the law in the United States. And as a practitioner and as a colleague of his, I will say that under oath. So the city of New Brunswick is lucky to have his skills and ability, and he's a much sought-after professional who works many places. It's a complex area, massive amounts of public funding and complex redevelopment issues, and he is the man, if I could say that, in this field. So Mr. Bier is here to answer any questions. We submitted the statement so it wouldn't have to be a big hearing in terms of going through each one. There's no mystery that he's retired. He's been on the scene here for many decades. I'm sure all of you know him. So the fact that it was his pension is okay, technical. We were here to admit that aspect of it. But again, the intent to evade or conceal or anything having to do with the purpose of these ethics laws, we think is not an issue here. The complaint and then there was a complaint filed in February of 2017, and Mr. Bier is here, and he can address his difficulty and amended what he thought was amended. He had to go back and fix it. The complaint about the reorganization meeting in 2016, we really don't believe has ethics implications. There was, at worst, an inadvisable parliamentary choice about how to run that meeting. But those meetings there's only a legal authority on behalf of the commission to approve contracts, and the voting members have to do that. Recognizing the perception that such a procedure could have, it was immediately changed the following year, and of course now the newly elected chair takes the gavel immediately and then runs the agenda. So I think that, you know, again, where there's the procedure's obvious, the minutes are, you have them, but there's no ethics violation. That's a consequence of that way of running a meeting. So at this point, Mr. Bier, if you want to make a statement, but certainly any of you have any questions, I don't want to belabor the hearing.
Council?
Well, maybe I could just to get it on the record and clarify where we stand. The pension issue not being listed, I guess the first time you listed the pension was, what, 2016, was that?
If I may, Council, yeah.
Yeah.
It's why I had to do this chronology, because it's a little exhausting. But, you know, Charlie Crowell, the complainant, who also runs the New Brunswick tomorrow. Today, tomorrow. It's today's news, yesterday. Okay. Who runs New Brunswick today? He, Charlie attends our meetings, and, Charlie did engage me in conversation prior to his article, but didn't tell me the specifics of what his complaint was. When he then published, we had a couple conversations, but Charlie would never tell me specifically what his issue was. But he published, and when he did, I immediately self-reported myself. As you know, Charlie found my pension. It's not hard to find. It's a public pension. All you have to do is put my name in, as Charlie did, into any search engine, which Charlie did, and Charlie was well aware that I worked for the city, and there was. Until Charlie filed that, I had not realized that a pension, either government pension, private pension, J&J, Social Security, disability, were reportable sources of income. I saw them as, I understand they're not earned, they're no longer earned. I just thought of this in the context of earned income. Immediately called the state, spoke to the Attorney General, as I've indicated here, and she was quite clear that any source of income that was pensionable is now one that is reportable, period. I went online to attempt to amend, as I indicated to this board when I self-reported myself. I reported myself, I said that I would file an amendment and correct this. We went online at that time, when I say we, because I have someone that assists me, because if you're learning, if you've never done this, and perhaps you do for this board, the state's website's not the easiest website to navigate in the world. We went online, at that time we were also then doing 216, so it was a 216 for 215 situation, and then a 215 to go back. Because at that moment in time, when I went, and again, I have all the dates and all the people we spoke with, you can call the state, they're there by name, okay? And when we called them, and at that time, you can only go back to 2 years. So the current year and the year I was working, the 215 year didn't post to the system. It wound up going to Camden or someplace, but it didn't post to the system. 214 was not capable of being amended at that point in time. And Charlie, appropriately, went there, he read the letter, and then Charlie went to look for the posting. He didn't find it. Charlie then filed a complaint against me for not doing what I said I would do. When I filed 216, then the Attorney General referred me to this LFB, Local Finance Board.
What being local function?
LFB, Local Finance Board memo.
Oh.
Okay, memo, yes. Local Finance Board publishes notices. There was a Local Finance Board notice. In that notice, in more detail, because when I was speaking to the Attorney General, he said, "You're my third call today on this issue." Now, my third call that day on pensionable. Okay? So I said, I better read this thing, because I thought I knew what I was supposed to report, but I better get clear about this. Went back, and then it's any source of income, earned, unearned. So unearned can be if I gave somebody a loan and I received interest. So now, in 216, I'm more fully disclosed, okay? Charlie read my 216 looking for my 215, and Charlie filed a complaint against me, as he has in his allegation, saying, well, if Mr. Bier reported in 216 these items, he must have been not reporting them in the past, which I've acknowledged is correct. I didn't report them in the past, okay? So I amended 216. I've since filed 217. In 217, I have some other items that did not occur previous, but then of course in 2016. So there was another item or two. I did not know that I live here in New Brunswick. I live on Livingston Avenue. My home is my home office. I live in one of the Victorians. I do have colleagues on the first floor that have office space. Again, I've always lived home office. Didn't think that my home office was disclosable, but it is, so I did. My other property, which I do have, and Charlie has acknowledged it, the boats and boat slips, those things in Neptune are just floating docks in a bunch of water, they're not homes, for which I lost a lot of money. Those floating sticks were a business. I understood they were a business. I've always reported them, they've always been in my forms. Never been not concealed. It was quote-unquote real estate in New Jersey, and it produced income. Those were reported. As well as the partnership that owns it. Even though technically I could have done a workaround and not reported the real estate, because it's not owned in my name, it's owned in a partnership name. But I didn't do that. So I disclosed the real estate, the partnership, and the fact that it was a source of income. One of the loans, which I did then disclose, one of the business entities I'm involved in, again, which Charlie has reported in his newspaper, and has always been on my forums, and there's nothing illegal about it, is a partnership that has offices in New York. That partnership made a loan. I didn't disclose that loan. When I went back to review documents, again, as a result of Charlie's complaint, to make full disclosure, because I want to get this thing clear and done with and before this board, I saw that it was not only the partnership, but my name personally. Consequently, that was the one that I disclosed that was not previously on. Okay. So I went through everything and attempted to disclose as fully as possible. The Florida property, New Jersey, non-New Jersey properties are not required to be disclosed. However, I retired, as Charlie knows, in 2008. I retired, I had cancer. I left the active practice. That was my condominium. After I recovered, I came back to work, I rented my condo. It was never listed previously and does not have to be listed as a non-New Jersey asset. However, I do collect rent from it. I could have easily not listed it. Charlie would have never found it. But I listed it and acknowledged that I had collected rents. Since it was a non-New Jersey asset, I hadn't thought that it was one that I needed to list. But again, going through everything, wanting to get everything listed that is now listed. And the rest is, I don't want to bore you, you can see how difficult it was. Once we could go back, that 214 was after the fact by the state. Now they've assured me, and unless Charlie you found that last reported, they assured me, the state of New Jersey, that 214 is their hard stop because they moved from a prior computerized system to a new system and then another system. And they're only going back one legacy system, okay? So that is as far as I can report, okay, is 214. Now, if they amend that again, as they did the last time, I'm not gonna know about that. They don't send you a notice, okay? But when I filed this answer to Charlie's complaint and his amended complaint, I've done everything that's possible to be done to amend. I'm not asking for any special treatment here. There are violations of reporting that occur. I don't dispute it. I adopt everything that my counsel has said in this document. I failed to report properly, okay? None of these things relate to my job in the sense of political corruption or anything, any special favors that I receive. Relative to the board meeting, I do want to address that. Charlie does attend as many meetings as he can and often does attend our reorganization. It has been our practice at reorg, because the chairman steps down because there's elections. Usually, we didn't go through the process of the chairman steps down, and then he steps back up, and then handles the rest of the meeting. It was our policy that I, as general counsel and parliamentarian, just handled the reorganization meeting. I called the election of officers, and again, Charlie submitted a transcript, and he has online video, and I dispute none of it. It's all accurate. There's no question about it. Okay. Our process was, we do the elections, and then we hire, as many boards have to, as government does, the retained professionals, of which I am one of them. That is correct. In fact, as Charlie's noted, I'm two of them. I'm both an attorney and a parking consultant. I have a practice in both areas. Okay. And this is the imperial bit, the New Brunswick Parking Authority, as an agency, puts those professional services out and secures those professionals through an RFQ, request for qualification process. It's competitively bid, responded to by, it's an open process, it's advertised. Anybody that cares to bid for those jobs may. I do not prepare the specifications, nor do I put the bids out. Those bids are received by our purchasing agent and the executive director. I do not participate in receiving the bids, the RFQs. I do not participate in evaluating the RFQs. That's done by staff, in-house staff. Once that's done, they make a recommendation, and the commissioners vote on that position. In the context of the reorganization meeting, quote unquote, as chairman, I'm really the secretary calling the roll. I'm no different than what your council is doing right now, calling matters. I call the agenda. I can't move it, I can't second it, and I can't vote on it. I can't take any official action. Simply was saying, this is the list of items we need to do today. This is the agenda. Commissioners can accept it, reject it, not vote on it, choose to table it, do whatever they want to do with it. I'm just simply saying, commissioners, do you want to vote on these items? Since they've already made their selections in advance, they usually do it as a consent item, which is not uncommon even in any government bodies. Rather than call 14, 16 separate motions, separate seconds, 16 separate votes, you ask if these can be moved as a consent agenda. Someone again makes a first, someone makes a second, and the commissioners vote on it, which is what they in fact did. Okay? That was my participation. Now Charlie, in that meeting, after the vote, I don't remember if it was before or after, I think it was after the vote, expressed his displeasure, that he thought the optics were not correct. That since I had a benefit, which he's filed the ethics complaint against me for, but since I was on that agenda as counsel, I was on that agenda as Bier Associates, that it wasn't appropriate to do it that way. After that reorganization, because that was 2016, in 2017, Charlie was there, and the vote wasn't called that way. As Charlie actually notes in his complaint against me that the process was changed. Charlie sometimes doesn't realize that his opinions are actually result in input and action. At the end of the day, after we discussed this amongst ourselves, we said, well, you know what? We don't think what we did was wrong, but maybe it doesn't look right. Consequently, in 2017, the meeting was handled differently. Pretty much it. I mean, there's another item in Charlie's second amended complaint relating to the reorganization, but there was no ethical charge. Just simply noting that Commissioner Galati recused himself from voting on me because I was representing him in a transaction. And he appropriately disclosed that, said that there was a conflict and he would not be prepared to vote on me. So it's in the amended complaint, but it's not, Charlie didn't charge any ethical conduct because Commissioner Garlotti recused himself. I think I would.
I'm not even considering that an allegation,
Right.
it's just.
No, I understand, but
statement.
you know, Charlie's here, and I just want to, you know, and he's filed written complaints, he's written articles, and I want to address all those items. And I think at that point now, I think I have. So that's my statement.
I have a question.
Yes.
Just a couple of things, sir. You know, council said it, you said it, you said it yourself, that, you know, there was a perception of impropriety, which was corrected with the parliamentary procedure, and that's absolutely, I believe that wholeheartedly, that change was made because of the complaint.
Absolutely.
And that's what, you know, but just a question of the bids themselves.
Yes.
As far as setting the agenda about the order of who opens those bids, which ones are seen first, do you have anything to do with that?
No, that's not done at the reorg, that's all done in
Okay.
advance of the reorg. Yeah, the reorganization is just the adoption of who they've decided they want to retain.
And then do you have any vote on the bids?
No.
Okay. That's my question.
I have a question.
Sure.
You found out in, I guess, February of this year that you could amend the 2014 forms. Did you do that?
Yeah, yes, yeah. We
It
went back,
just
yeah,
wasn't
I'm
clear.
sorry. Yeah.
I knew you amended 15,
Yes.
but it wasn't clear as to whether you amended 14.
Yes, went back as far as the system would allow.
Thank you.
Yeah, thank you. You know, because I was surprised when Charlie, you know, filed the complaint, I understood the 15, and I was surprised to find they hadn't posted. But then when the additional allegation was I hadn't done 14, I said, well, that's a physical impossibility, I can't do that. So then I called Trenton, and they said, oh, sorry, sir. You know, because, look, they're busy people, and they don't keep records, and after I call you up and say, oh, you called me, literally 1 month later. So had I delayed, although then I would have passed my deadline on my filing for the current year, but had I been late, I would have found I could have filed 3 years. They did it 1 month after the deadline for the 16th filing.
Does anybody else have any other questions?
Do you have a copy of your most up-to-date 2015 FDS filing?
I think I saw, I believe so. I think so. Charlie, you have it? A lot of paper. Well, because it used to be physical. It was actually a lot easier when it was physical. 2015 amended. These are my originals. I mean, with my associate's notes on it. But yes, I have it. Well, I don't have photocopies of it.
So,
Maybe there's a way we can make a copy here.
perhaps, your testimony is that the deficiencies on the 2015 were all corrected?
Yes. Yes, that is my testimony.
Yeah.
And 14.
Yes.
Yes.
And 14.
14, 15, 16 was new, 17 new. Yes.
Including each of the items that were listed in
Yes.
Mr.
Yes.
Cradville's
Yes.
complaint.
Yes.
I'm sure so many of these reports have seen double, I think, but,
You and me both.
so you're not contesting the fact that they were incorrectly filed initially?
No, I am not. No, I admitted that in the first statement. Yes.
And with regard to your presiding over the reorganization meeting, was that an unwritten policy or?
It was custom, it's an unwritten policy. The custom had been that the chair would step down during that process and then take the gavel back. Because once you conclude, the reorg is just simply election of officers, and There are statutory requirements for reorganization for parking authority, as there are for many other independent entities, authorities, or commissions, which require, you have to adopt a meeting calendar, you have to adopt the official newspaper, as you read tonight, Home News Tribune, and Star and Life, the same papers we have. You have to have your meeting schedule, because it must be posted. You have to have, we have affirmative action officers, that must, and it's an employee, that's on a bid. But again, every year you must acknowledge who that is. You must have an OPRA, Open Public Records Custodian. Again, it's an employee, it's not a bid item. Then there are professionals, and in the parking authority, we hire a general counsel, a bond counsel, labor counsel, engineer, architect, auditor, appraisal services. These are all the things that we need to do our business on a regular basis. And those people are retained for 1 year, which is the maximum. It's the maximum period by law in the state of New Jersey that a professional may be retained. So every year, we must re-retain professionals. So these items are pretty standard. There are some other things that we must do, that's what's called a cash management plan. The state of New Jersey requires us, because we do handle money, to acknowledge all of the accounts, bank accounts we have, what banks that they're in, and the purpose. So it's a list, and as I say, it's 12, 14, 16 items, and it's standard. Relative to the retaining of professionals, which are, somebody has to make a decision on, it's not staff that does it. Yes, I am not involved at all in the procurement, evaluation, or the voting process. I simply called the roster. I simply called the agenda and the items to the attention of the commissioners who voted on it.
I think the board probably understands the situation. There doesn't seem to be any great factual conflict. It's more a matter of interpretation of the facts. I want to note that the board has received a written message from Mr. Prattville saying, to the Ethics Board, as I explained to your attorney, Mr. Jost, earlier today, I would like to be heard as a witness in the Bier matter. Please allow for this to occur because my testimony will be relevant to your deliberations. Charles Prattville. Perhaps we want to follow the same procedure and go into executive session to discuss whether we want to permit that. Although, frankly, I'd be more interested if Mr. Prattville submitted specific questions in writing to the board that you could consider. But you could also consider the question of whether you wanted to permit him to testify.
My question to Mr. Prattville is the testimony. Is it additional information from what you've already submitted?
Yes, it's the specifics of what happened at the January 2016 meeting, including exact quotes.
But that's part of the transcript of information that we've already received, right?
No, there's been no transcript provided beyond the complaint. I do have a copy of the video of the meeting, should you care to watch it. I have one from the other, for the council as well. If I have 2 flash drives with the video, if you'd rather watch it, that's fine. But short of that, since maybe technology won't allow, I can just tell you what what I witnessed, how I came to file this complaint, and I think it would help.
Counselor, do you have a position on this?
I do. I think, first of all, what happened at the meeting for purposes of this hearing, I think, is factually, the record is sufficient. Mr. Bier has testified with complete candor as to everything that happened here. I don't know what could additionally be in dispute that would be augmented by adding new information to the record, quite frankly. I also think there is a procedure where a third party from the audience can submit written questions to the chair that can make a decision. That's the appropriate way to handle this. I certainly think that if this was a case where there was some controversy over what happened, or a witness who was denying certain things, and there was other evidence needed to reach a conclusion, that might be a different situation. But, so we would be opposed to adding any other evidence to the record, in light of the way this has been presented this evening.
All right,
I recommend that we go into a closed session
All right,
to discuss
Before we
this.
do, I have one question.
Chairperson, yeah.
I understand that you were presiding over the agenda and called the agenda. I'm assuming you did not write the agenda.
No, I did not. No, thank you. No, I did
My
not.
only question is if you're gonna testify to something, shouldn't that have been in the original complaint? Though, that information, shouldn't we have gotten it sooner? Because it kind of hits us by surprise here, and then we may have to adjourn and do all this over again, or some of it. How come you didn't do it in the original complaint?
I contacted your attorney today to try to make arrangements to show the video.
Okay.
Obviously it's not going to happen tonight. And I heard testimony, quite frankly, about, what was said at that meeting. Mr. Bier says he said something to the effect of, commissioners, do you want to vote on these items? And I have testimony that will
So
contradict that.
it's to refute what?
Exactly. Since my name was mentioned so many times, I feel I should set the record straight.
All right, the chair has recommended that the board go into executive at this time to discuss both the evidential issue and the case in general. So, does someone want to move that?
Make a motion that we go to executive board.
Anthony? Second by Larry. All in favor of going into executive?
Aye.
We're back on the record. The board's met an executive session, and I believe the chairman has a ruling on the issue of the additional testimony requested by Mr. Gradeville.
We are not going to allow additional testimony regarding the issue, the complaint. We think that we have enough information. Mr. Crowley has had time prior to now to submit any other additional information, so we're not going to hear any other additional information coming over that. We are going to defer decision on this until our next meeting, and so 30 days or so we'll meet again to bring the final resolution regarding this matter.
Yes, the board does not feel that the additional testimony from Mr. Gradeville does not feel that there's sufficient or really any material issues, factual issues in this case that require additional outside testimony. The board has requested that I prepare a proposed resolution on this matter for consideration at the next meeting. I presume we'll have a short executive session at the next meeting to review the resolution before entering it onto the record. And beyond that, I think we need to come up with a date for the next meeting. And also, there was, I think, one change to the minutes. Nora, did you
Yeah, I
have?
wanted to make a change to the minutes. And the minutes, it says...
This is the minutes of which meeting?
This is the minutes of June 26, 2017. It says, it's the last sentence under public comment, and it says, concerns were made by Mr. Crowdell about Leonard Bier and receipts or lack of receipts for a trip to Alabama and what took place on this trip. I believe it should have been Ms. Eato-White and not Mr. Bier.
Yes, that's right.
I'm not in trouble.
So the
Looking forward to it.
minutes will,
Be careful what you ask for, sir. I was stationed down there for a year.
did the board vote on the minutes?
No.
why don't we have a vote on the minutes as corrected? Does someone want to move that? And second? Second? Oh, you seconded it. You made the motion?
Well, I was entertaining.
Each entertaining the motion. So you make the motion? Alright.
So it's probably moved to second, all in favor?
Now, with regard to the next meeting, do you want to try to set a date now?
I think you should do it at another time and have secretary and whomever, let us use the same process we've used in the past.
Okay.
We're making phone
So we
calls.
will try to come up with a meeting probably in September. Okay.
Thank you, we were gonna ask about the
Yes,
scheduling.
yes, it's
Sure.
tough, it's very tough
I appreciate
meeting
that.
in August.
And it's not going to affect the 30-day deadline for Ms. Eato-White. Is that correct, sir?
Right.
No, she still is obligated, she can send a written communication explaining what she has done. And so that would end the hearing portion of this matter, and the decision will be made at the next meeting.
Thank you.
Thank you, Charles.
So, going to the agenda, is there any new business that we have to add to the agenda?
I just wanted to mention, I don't know if this is new, I should have a recommendation for you. I finished my research on the Yola matter, so I should have a recommendation for you at the next meeting.
Is there any other points of discussion from the board members? No? Okay. We will open the floor to any public comment. Yes, Mr. Crowder.
Yes, thank you for hearing my complaints today. I was disappointed that I wasn't given a chance to speak on either of them. I understand that, you asked the complaint to be in writing, the complaint's in writing, but quite frankly, what was conducted today was a one-sided hearing, especially with Mr. Bier. He was allowed to give his side, he was allowed to make representations about what happened in places, and I quite frankly wanted to share with the board how I came to get this video of this meeting and what it shows. And
Mr. Catterville?
Yes.
If you're going to talk about the case that we finished talking about, I'm going to end your public comment. If you have additional comments you want to make other than that particular matter.
okay, so you're saying comments on the case are off limits, cannot comment on that case?
Yes.
Okay, I think that's exacerbating the problem that I was just speaking about, that you won't hear both sides.
But you're getting ready, we've said that, we're not taking any other, any comments or regarding the case, and you are now.
Well, also, Mr. Bier has left the room, and his attorney is not present, so it wouldn't be appropriate to hear additional comments on that matter at this time.
And frankly, we did hear, this whole complaint was extensive. You gave us a lot of information here. There was nothing that we thought that was lacking in your presentation. Everything you said, I think that we believe was addressed.
Okay, has the board seen the video of the meeting?
No.
Okay, would you like to?
Not at this
Since you have till, you're not gonna have another meeting till September? It's
I
only
don't think it's necessary for a
6 minutes,
decision.
6 minutes of relevant video that show the action. There was a slew of omission of income violations, but there's also
We're
an
getting back
action
to the same,
violation. There's an action violation and it's captured on video. And I'm asking if the board wants to review the video. I brought it with me, I contacted your attorney to try to make these arrangements to support my case. It's here, I have a copy for you. It's also been
I
on.
think we already addressed the action violation, though. I think we did.
Well, Mr. Bier said that he told the commissioners, do you want to vote on these items? And I have a transcript here of what actually was said, and that's not what was said. Indeed, he said, quote, I'm going to go through the reorganization resolution so we can do this as a consent agenda.
I think for purposes of this particular matter, the board thinks it has the information it needs to make the decision.
Okay, well, I would encourage you to not issue a suspended sentence as you did for the other respondent, because we really need to set an example that these folks that are in power need to be held to the highest standard, and ignorance of the law is not an excuse. You can't say, I didn't know I had to do that. And I think part of the problem with the first respondent's case was that the person who was supposed to be giving her the guidance and advice for how to fill out these FDS forms and when to fill out these FDS forms was the respondent in the second case. So absolutely, he needs to be held accountable. And I hope that you won't issue a suspended sentence. I hope that you won't wait until September to have a meeting.
We're getting off into arguing the case again, and the respondent is not here, and his attorney is not here.
I understand. I'm not trying to do anything untoward. I did try to do it during the meeting. in the
Why don't
proper
you
way.
wait till we make the decision, and then before you talk about this any further. Before you comment about, you don't know what decision we're gonna make, so.
That's true. Well, I will look forward to your decision. Is it true it won't be done till September, though, right?
Well, we're not sure of that. We're gonna have to see what dates are available. If September looks bad, you might have to go back to sometime in August. We'll have to judge what everybody's schedule is.
Pardon me, I just recall from the scheduling discussion that the 24th was going to be the go date, and then the 31st was going to be a backup date. Why can't the board meet again in a week or sooner?
There were problems with the 31st.
Okay. Well, then I'll just say that you should take into consideration the severity of the violation, the alleged cooperation with the ethics board, the expectation of the person to have knowledge and experience relative to it, and also their ability to pay a fine. And those would be the criteria that I would use. But I won't pretend to tell you what you should do about it. I just think that there's a lot of violations, and one that includes an action to benefit oneself. I don't believe you solicited written questions.
You're still out of order.
Okay, well, you didn't solicit written questions?
I'm trying to be,
So I'd like to submit written questions in lieu of
the time
testimony.
for doing that is past.
Did you offer the opportunity to?
Yes.
Check your video, you'll see that. Yeah.
All right, I'll double check, but I was hoping that you would ask some
You also,
questions.
I mean, when you submitted your request to make a statement, I would have thought that you would have submitted your questions, any questions you had.
Well, you guys went in a closed session, and you said you were going to evaluate that request, so, I mean, I didn't know, I was never asked. These questions were never solicited. I had them prepared. There's 6 questions that I think should be asked.
I do believe in your video, you're gonna hear yourself say that in lieu of writing questions and putting questions in writing, that you would like to give a verbal statement or whatever, however statement you want to say. That. So
Right.
that's what you did say, that you didn't want to do it in writing, you wanted to do it verbal.
Right, I was denied. Right.
Well, you said you didn't want to do it in writing, you wanted to do verbal, and we decided on that.
Right, you denied to hear.
Well, again, we're out of order here because the respondent's left, his attorney's left, I shouldn't even be discussing this case at this point.
If I may ask a question, why was he allowed to leave then if we're not through with it? I would like to ask a question.
The reporter's asking your name, sir.
I'm Albert Valeri, Bier, I think, from Second Ward, Balberi.
He was allowed to leave because the hearing was concluded.
Well, it couldn't have been concluded. We had questions that we could address to him.
I don't believe questions were solicited from the other members of the public either. So I don't think you've complied with that, and I'd like to just submit these. You can do what you want with them, but these are the
All right,
questions that I would...
we'll receive your written questions, and the board's going to have another executive session at the next meeting, so we'll take those under consideration.
Terrific. I'll shut up about Mr. Bier. I just want to remind you that you have one other outstanding matter, the Vignolo case, and I'm not quite clear why it has taken so long for the case to be resolved. I recall the first time we all kind of met and talked about it, I said somebody should get on the phone with the local finance board and contact them and see what the whether or not he's an LGO or not. And I mean, I kind of hinted that I had reached out to the LFB and they had given me affirmative response to that question. Has anybody reached out to the local finance board to find out if ethics board attorneys are required to file disclosure statements?
We'll have some comment on that at the next meeting.
So the board won't say whether anyone has reached out to the state about this? Why?
We're not going to get into that case. I indicated to the board that I would have a recommendation at the next meeting, so we'll consider that at the next meeting.
Okay, I just don't understand what,
You're asking us to make a decision about something we have all the information yet. We're still gathering the data today.
okay, well, it takes one phone call to call the state and see what their opinion is. I just want to know if that's been done. If it hasn't, it should be done. If it has, I'd like to know what they said. And I think that's reasonable because my complaint is also dated February 1st.
The matter will be handled by the board in due course as soon as it can.
Which is going to be September at the earliest.
Well, you know, these are all volunteers, they all have busy lives, and they try to schedule these things as well as they can. And it's trying to get all these people together at the same time. Sometimes it's like herding cats, you know.
Well, thank you.
Well, it's just that everybody's busy, you know,
Yes.
and sometimes the wheels grind slowly.
I understand. This is just, as I indicated, is an open shut case. The local government ethics law, 48:9-22.3 defines local government officer. And the state could clarify for you very quickly and easily whether or not Mr. Vignola falls under that definition it's called a managerial executive. And that definition again comes from a different statute, 34:13A-3. And if there's been confusion about it, as I informed you at a prior meeting, they actually went and made a new rule just to clarify who's in and who's out, who has to file and who doesn't. And when I called, I got a very clear answer that any board where the board members must file FDS forms, the attorney must also. And I don't think there's any dispute that Mr. Vignola was your attorney in 2015.
We will address all these issues when the board makes a decision.
Well, then in that case, I'll just close by saying thank you for attending, thank you for hearing my complaints, and I hope that you, at the soonest possible crossroads, dismiss Mr. Vignola as your attorney because of his apparent violation of the disclosure requirement that you're supposed to enforce. This board cannot have credibility if you're represented by an attorney that is not following the law you're supposed to enforce. And so I want this board to succeed. I want you have a noble mission, and I want you to fulfill it. And I hope that I don't think you can do it with Mr. Vignola as your attorney. So I hope that as soon as possible he is dismissed. And that's all I have tonight. Thank you.
So, any other public comments outside of the complaints that we filed? Okay. So we move to adjourn the meeting.
Motion to
adjourn.
Can we make the motion?
Second. All in favor? Aye. Any opposed?